And thanks for staying with the agenda. Let's take you now to Mzwanele Manyi, who is monitoring the corruption trial in Pietermaritzburg. Mzwanele, interesting developments. What's the latest on your side?
In essence, Desiree, I under my colleague and Zuma Kanya, who were inside court now, just received a briefing from the Jacob Zuma Foundation on behalf of its patron, Jacob Zuma, that the former president is not feeling well as it downpours here in Pietermaritzburg. But Anda Mhlongo was part of that briefing. We're going to ask her of the questions. Anda, the Jacob Zuma Foundation says its patron, Jacob Zuma, the former president, is not feeling well. So in essence, this means the former president will not be making his way here to court in Pietermaritzburg.
Yes, indeed, Sam. Mzwanele Manyi, a spokesperson for the Jacob Zuma Foundation, calling the media urgently to give us an update. That is that former President Jacob Zuma has been advised by his lawyers, by his doctors, not to be present in court today, as he said, as he is not well. According to Mr. Manyi, at the moment, his lawyers are now meeting with the judge to determine how they're going to proceed. He did indicate that while they are in discussions in chambers with the judge, it might take some time for the proceedings to start. We had expected that the proceedings would have started at 10 a.m. this morning, but of course now with this latest development that the former president will not be in court, we'll have to wait to see what the judge says and whether or not the trial, which was set to start today, is going to be able to proceed.
So in essence, what we are seeing is that with the former president being ill and not being able to come to court, with this application of a private prosecution as well to prosecute Advocate Billy Downer and his legal team's stance to want to bring an application to try and stop the criminal trial from proceeding today will further compound what is perceived as a Stalingrad tactic by the former president to stop the prosecution of this 17 years long criminal trial.
Yes, certainly, Sam, I suppose, but we will be speaking now to our legal expert, Mr. Mzwanele, just to, of course, take us through what is likely to happen now that the former president is not well and cannot be in court. Remember, Sam, that today, as we've said, was the start of the trial. The court had instructed former President Jacob Zuma to be present in court today, as well as a representative from Thales. We know that most of the time, I know we speak a lot about former President Jacob Zuma and less about his co-accused in the matter, the French arms company Thales, but their representative had also been instructed, and their representative comes from France, had also been instructed to be in court today. We'll have to wait and see what the judge says, but if former President Jacob Zuma is not in court today, it's unlikely, I suppose, that the proceedings will be able to get underway. But as I said, Sam, we are with our legal expert, Mr. Zigalala. Let's just chat to him on this latest development. Mr. Zigalala, thank you so much for your time this morning. We'll first start with this development now. Former President Jacob Zuma, his doctors have advised that he stay at home as he is not well. What is likely to happen now?
Probably an application is going to be made for the postponement of this particular matter, in which the former president legal team is going to make a presentation and say to the court, our client is not here, not due to his own doing, circumstances beyond his control, it's a matter of sickness, a matter of life and death, please grant us a postponement. Probably the judge will then say, provide you some proof of saying that the president is really sick and can't be here. And they may come back and say, I don't have proof at the moment. If you give me time to come back either on the next occasion, I can provide that particular medical certificate, which is important. If all fails, whether it's by consent or maybe the judge and the NPA says that let's go to court, the Criminal Procedure Act is very prescriptive. It says under Section 342, capital A, there's particular reasons which are looked at by the court to determine whether this delay is reasonable or not. And certainly issues of health, especially when evidence is going to be led, are utmost important. The court does not want to lead evidence when the accused is not there. You must be able to see the start of the trial, hear what the witnesses are going to say, and certainly they're not going to do this particular matter in absentia. There may be provisions under the Criminal Procedure Act of doing that, but I don't think those conditions are alive here at this stage to say let's continue even if the former president is not here. So the chances are the matter is going to be postponed to another day.
Regarding the former president's illness, we know that it's not the first time that he has not been present in court. In fact, it was a time when an order by this court was granted that should he not appear in what was supposed to have been the next appearance, and a warrant of arrest was to be issued. There was a dispute over the medical certificate. The judge at the time, Judge Pillay, had questions around the medical certificate that had been submitted to the court by his legal team. So you were saying that today, in order for the judge to grant this postponement, they would then have to furnish them with a medical certificate that would be acceptable to the court.
Definitely, but also depending on when the illness took place. So if you are sick yesterday at night, you probably would have received the chance to go to the doctor this morning. By this particular time, you can't go to the doctor and get that particular medical certificate. So what they are going to do, they're going to say, grant us time. We are not disputing anything. We are not fighting with anyone. We just need adequate time so that we are able to file this medical certificate. We are well aware of what is going to happen. But what we can come here and say is that our client, which is the accused in this case, is not at court. He's not feeling well. On the next occasion, we're going to come with a full medical history and the instances which have caused this particular delay with the medical illness.
I want to go back, Mr. Zagalala, to speak about what we had expected to take place here today in court. The former president, Jacob Zuma's legal team, the intention was for them to file an indefinite postponement, and that is due to the fact that, of course, he's approached the Supreme Court of a appeal to reconsider their decision, and that decision was after the court dismissed his review application for the SCA to review the Pietermaritzburg High Court's decision, where it dismissed his application to have the state prosecutor in this matter recuse himself. It's a mouthful, I know, but this indefinite postponement, in your view, was he likely to get it? And I say this because the judge had made it clear. We were with you in the previous proceedings as well. The judge had made it clear that he wants this case to get underway, and he did not want any more delays.
Of course, we're speculating because we haven't seen the papers, but it's very rare that a court will give out a decision similar to that one. Indefinite prosecution up until you finish traversing all the other courts is not going to suffice. Let's also remember what governs the way the procedures that must be followed in this case is the Criminal Procedure Act, and it is very prescriptive in terms of saying there are instances when you are not going to listen to any of the postponements application which you come with as the accused. If there's anything irregular or illegal that has taken place, the Criminal Procedure Act is going to take care of that. When you go through your appeal stages, that is what you are going to traverse and deal with those matters at that particular stage. For now, we still want the merits of this matter to be discussed, and we want the first witness to come into the witness box and discuss and give out the evidence. So I don't think that particular application would have succeeded. The judge would have said, I want to get this matter over and done with as soon as possible. In fact, I'm protecting your rights as the accused. It's per Section 35. It's your right that the matter must start and end within the shortest amount of time. There's been numerous delays in this matter. I don't want those delays anymore. Let's please get on with the matter.
The matter, though, that he wants to pursue his private prosecution of Advocate Billy Dunn. I was speaking to you earlier on that it's a recourse, I suppose, that a lot of people are not familiar with. Private prosecution. If you can just take us through exactly how does it work?
It's basically governed by the Criminal Procedure Act. I think from Section 7 to 18 it deals with private prosecution, but basically stating in instances where the NPA, which is the ordinary prosecutor of all us or represent us in court as South Africans in criminal matters, they will then say you're not interested in prosecuting this matter, and then you say to them, because you're not interested, please give me a certificate. I want the title to prosecute. Ironically, it's something which has been dealt with before in this court. I want the title to prosecute this matter on my own. I I've provided the financial security just in case I lose the matter. I believe that I have merits. Give me that option because I want my instances or my matter to be traversed in an open court. So basically the president was going to do that. But it must also be remembered, it's not something which can be used to delay the starting of this particular matter. It is a private matter which is against the former president and advocate Billy Down. It has nothing to do with this type of proceedings, and it had no bearing at all because this court is pronounced on it. The SCA, let's say part 1 of part 2 has been pronounced on it. We're still waiting for the Concord to determine, but it cannot be used as any of the reasons in which are going to stop this particular proceedings from taking place.
And of course, the NPA has said in this matter that all of these are just tactics, Stalingrad tactics by the former president to delay, and they are going to vehemently oppose any application that he brings to this court.
I wouldn't agree with them to the fullest extent. Let's remember, these particular points or issues or legal frameworks that they're using is something which is available in our law. They wouldn't have been inserted or created if they were not meant to be used. So at the end of the day, if I have a client, in the case of the former president, I'm going to use all that I can to make sure that his rights are defended. So if I'm traversing all those particular avenues to make sure that he gets a fair trial, to make sure that he's able to get access to justice, those avenues are going to be used up until they've been exhausted, and then you can start with the main trial. So I don't think it's a delaying tactic. It's simply the former president saying, I have these at my disposal, I'm going to use them by all means. I'm still going to instruct my legal team to pursue them up until I get finality. I want to make sure that if I'm prosecuted, it is done so in line with the law, but most importantly, I must be able to see and hear justice being done.
Before I let you go, and I know we will be with you throughout the day, but another important point that has come up, that has been reported, is what is contained in papers that former President Jacob Zuma's lawyers have submitted to this court, where they, or some are saying that it's perceived or appears to be a threat to the court where he is, we understand, reminding the court of what happened to when former President Jacob Zuma was incarcerated, and the unrest that followed. What do you make of it? Do you think it's a dangerous line for his defense team to take?
It may be a dangerous one. Let's remember, why would you want to link your client to something which happened, which is very bad, and to something in which they've always came out and distanced themselves from it? So if you are going to say, do not let the legal frameworks, do not let the Constitution take precedent, do not allow the rule of law to reign, because there might be fear of certain unrest taking place. That's basically putting or placing the court in a corner. Let's call it legal blackmail. So you don't want to have to engage in those type of tactics, especially you don't want that type of content within your affidavit. If you want to argue and want to protect your client, still stick to the legal frameworks. Show the court which particular rights are going to be infringed by that decision, and show the court the level of success in which that is going to be attained if they traverse those particular legal frameworks and legal precedents. So I don't think that particular phrase should have been included. However, the legal team is at liberty to insert whatever that they want in an affidavit. Whether to sway the court, I don't think so. The court will always be independent. They'll always rule without any fear or favor, and make sure that the only thing they seek to protect is the rights of the accused, the Constitution as it states, and any other common law legislation which must apply to all the circumstances, especially in this particular case.
Mr. Zigalala, we always appreciate you helping us out and your analysis on these matters. I know you are going to be with us for the remainder of the day, but we do appreciate your time. Still a lot more to talk about, of course. As we said, that breaking news of former President Jacob Zuma will not be present here today at the start of his criminal trial here at the Pietermaritzburg High Court. Currently, his lawyers are in chambers with the judge and with the prosecution team to map out a way forward, Sam, in terms of what is going to happen. And while we've been focusing a lot on what has been happening on the inside of court in terms of what we can expect from the legal proceedings or the court proceedings expected to take place this morning, there's also a lot of attention and focus on the outside. Or in case today it's in the court foyer, because everybody's trying to to run away from the rain. But just outside the court, once again, the road outside the court has been cordoned off by the police, a heavy police presence here outside the Pietermaritzburg High Court. Of course, police monitor and ensure that everybody who is here is safe and that there are no incidents that may take place outside. Sam, speaking about the people who are here to support the former president, the usual faces we see, a spokesperson of the MKMVA, Mr. Carl Niehaus, he's here. We've also seen Kosenje Shezi, responsible for the mobilizing of to mobilize support for the former president. We just saw Dudumieni as well walk past us early on. Usual faces?
Yes, indeed. The usual faces are here in court. We've not seen the likes of Supra Muhamapelo, who is the former provincial chair and former premier of the Northwest Province, who's a member of parliament. He's not yet here. The likes of Des van Rooyen, Malusi Kikaba, who's also been here to support the former president, is not yet here. I've seen those who work in the suspended Secretary General Ace Makashule's office, the likes of Chris. They are around. They've just left, in fact, now saying that the suspended Secretary General of the ANC is around town, and we did speak on the phone with him. It did say he will be coming to court to support former President Jacob Zuma. He's been here for quite some time now in KwaZulu-Natal, particularly heading towards that eThekwini Regional Conference, which he says he didn't know where the venue was, didn't speak to anyone, didn't have any meetings, but he is around town. And we've also seen Mthandeni Dlungwana, the former MEC of Education, who hails from Mpendle and former regional chairperson of this region. He's just stepped out now to go do some of his own private business. He was inside court. So the usual suspects are here, and the usual supporters of former President Jacob Zuma, particularly after they are gloating in victory with the victory of Zandile Kumete as the regional chair of eThekwini, whom, by the way, also supports former President Jacob Zuma. And she's not here in court right now. She was celebrating with her family after yesterday's victory. And our colleague Simphiwe Makanya did that excellent interview with her yesterday evening. So those who support former President Jacob Zuma are here. They are pledging their allegiance to him, and we are seeing those whom are in his corner in an upsurgence when it comes to electoral politics within the ANC once again in the province.
Yeah, certainly, Sam. I do believe, and you've always said that they use this court case as a platform, I suppose, for them to come together, the supporters of former President Jacob Zuma. This is the time where they are able to get the masses, to be able to speak to them on the current situation and the current politics within the ruling party. But yesterday we spoke to Pastor Vusi Duba, who also knows, also part of the committee that organizes the support for the former president. And he had said that why we're not seeing the masses here today would be, obviously with the start of the trial, they weren't too sure whether or not it was going to get ahead. But should the trial continue, he then said that they will be mobilizing the masses to come out here. But saying that they were not going to stop individuals who wanted to come and show their support for the former president. But today we are not likely to see the numbers outside and all the preparations with the stage set outside just opposite the court building. We're not going to see that today. They're going to play it by ear to see what happens today. And they said should the case then continue from tomorrow or continue into tomorrow, then they were then definitely going to have the masses come out here. But of course now with this development, Sam, with the former president being ill, and we'll just have to wait and see what the court says, whether or not the matter is going to proceed. It's, as we said this morning, it's all in the former President Jacob Zuma's court.
Indeed, it's all in the former president's court right now, and he is seemingly ill, and he will not be here in court today. The political theatre will not be taking place today. There will be some of it in the foyer of the court, but when it comes to the market square here in Pietermaritzburg, there will be no such political theatre. As it rains and pours down like cats and dogs, there will be no political theatre. Those who support the former president, some of them will be making their way. The leaders will be coming through to support the former president in absentia, as he's currently ill and will not be in court, as the political theatrics and the political tectonic plates shift in the province back in favor of former President Jacob Zuma, with Mama Zandile Kumete being elected as the regional chair of eThekwini and Tumbo Ntiulu being elected as the deputy chairperson of the province, who's effectively now the acting chairperson of the province, with Mam Zandile Kumete having stepped aside. Mam Zandile saying she will be there on an advisory role, advising those who are in and who have been elected. But the political theatre currently is in court as the legal and the politics join together, as you've seen those papers by former President Jacob Zuma, when it comes to the letters and the affidavits he submitted to Judge Pietermaritzburg linking the July unrest to former President Jacob Zuma, should this criminal trial proceed with the events that we saw last year with the arrest of the former president. Back to you in studio, Desiree.
Samkele, while we still have you, we actually been showing shots from inside court, a baffled legal team there, but we missed parts of that announcement by the spokesperson of the Jacob Zuma Foundation, Mzwanele Manyi. Besides the announcement of the president not being well, do we know what else was said? I hope you still have Ayanda with you.
Well, and I'm just going to quickly bring in some of the points that Mzwanele Manyi raised in that impromptu briefing. What are some of the points that he raised besides the former president being ill and the lawyers of the former president and the state now being locked behind closed chambers with the judge? What are some of the other points that did Mzwanele Manyi raise?
Sam, he stuck just to that, to say that he is going to be updating the members of the media and the country shortly once they get a report back from the lawyers regarding the former president's ill health and how the court is going to proceed. They are going to be giving us, once the lawyers have met with the judge and have met with the prosecution team, they are then going to be giving us an update in terms of the way forward and what we can expect today.
Well, and thank you very much. I've just seen visuals now of Judge Pietermaritzburg entering court over to the court for the judge's proceedings to start.
Thank you, my Lord. Mr. Jackson, I appear on behalf of the second accused, and maybe whilst on my feet, my Lord, you would not necessarily note, but there is a different representative on behalf of Thales in the dock. We have a resolution. The reason is that a previous representative is not available and we did not want to cause any delay in this matter. I beg leave to hand up the resolution. I have discussed it with Mr. Downer and also with the other representatives. You would see that it makes provision also for a second representative, but just that's in case there's a problem when he's sick or whatever the situation is, can't be here for a day. The new representative, my Lord, that you will see from the resolution is Mr. Olivier, and the pronunciation of the surname is Kuzerka. It's Mr. Olivier Kuzerka. Okay. Kuzerka. And we asked the court to consider to then accept him as the new representative.
Yes. Shall we make this a further exhibit?
I think
we're down to exhibit E.
Exhibit F. Your Lordship's registrar told me exhibit F.
So this will be F.
F, yes, my Lord.
Thank you.
Thank you, Madam.
Yes, the resolution passed by the Board of Directors of the second accused will be exhibit F. And I've taken note of the fact then that Mr. Kuzerka is present here today.
He is indeed, Madam.
Thank you. Thank you, Mr. Kuzerka. Thank you, Mr. Roo.
My Lord, could I just say that is in terms of section 3322B of the Criminal Procedure Act, and that if your Lordship has regard to that, it's strictly speaking at the application of the prosecutor. Now, I absolutely have no problem with it at all, and so I formally make that application.
Thank you for pointing that out. Thank you. He is then so appointed as the representative. Yes. In the order of business, I think, Mr. Mpofu, you next to speak, is it?
That would be correct, my Lord.
Yes.
Yes. My Lord, if I may just start with a few housekeeping issues. Firstly, as we indicated to your Lordship in chambers, your Lordship will notice that the first accused is not in court. There was a medical emergency which took place in the past few hours, and we have been liaising with the doctors. The situation is being attended to. I've now, since we spoke to you, my lord, been assured that we might get some kind of document later in the day. But be that as it may, the proposal that we had discussed in chambers was the possibility of being able to proceed in the absence of the first accused. And obviously, as I indicated to your lordship, I had to get instructions in that regard. I'm happy to announce, my lord, that I have since received those instructions. And so we will be able, we'll monitor the medical situation, but, and I've personally spoken to the Surgeon General.
Surgeon.
Yes, so I kept on calling him the district surgeon earlier, but he's the Surgeon General. And, and he has given me that assurance. Now, the basis, of course, of the agreement was that is similar to the previous one that we had, my lord, you'll remember, in September, where the accused had, although he was entitled to be present, for the sake of progress, agreed that we could argue the Section 1061H matter on the 21st and 22nd of September.
Yes.
Mr. Dana and I have identified what we think is the correct section, which incidentally also deals with postponements, but also deals with absence in general, as Section 159 2A Roman 1, my lord.
Yes.
Yes. So
Yes, as I understand it, he's instructed you that the application for an adjournment can proceed in his absence.
That's correct.
He waives his right to be present during those proceedings.
Yes.
And no consequences will follow from him not being in attendance.
Yes.
Because
in the same way.
Because in any event, everything is on affidavit.
It's an affidavit, my lord. As I say, we're exactly in the same position we were in September last year, where practically it's an application, although we know it's in the criminal court. So yes. So
Yeah.
that is it's that same arrangement, my lord. Maybe Mr. Dana can confirm.
Yes.
that
You
is-
confirm that, Mr. Dana?
I have no objection, my lord.
Yes. Yes, it's noted then that Mr. Zuma is absent. He's not in personal attendance, and that he has agreed to the matter proceeding. When I say the matter, the application for postponement or an adjournment proceeding in his absence.
That's correct. Right. My lord, oh yes, another housekeeping matter is that actually how we got to know all this is that last night we were supposed to be consulting with Mr. Zuma, and he couldn't make it. And one of the reasons for that consultation was, of course, he would have signed the supplementary affidavit that would have reached your lordship on Saturday. I've mentioned to Mr. Downer that we have therefore not been able to have that signed. He has no objection in it being referred to. If need be, the formality of filing a formal one would follow.
Yes, I don't, Mr. Downer, you confirm that as well?
I confirm that, my lord.
Thank you. From my side, I don't have a problem with that. The unsigned copy that I had, or that I was given, referred to an annexure being the cover sheet
The face,
of filing the reconsideration application in Bloemfontein.
Yes, ma'am.
I obviously do not have that, and if that can be handed up and I can see the date on it,
Yes.
then I'm satisfied that
All right, my
that
lord.
part of the factual matrix is also
Is
established.
done. Yes, my
I was
lord.
told it's the 8th.
It is, my lord. You can take it from me for now. We will generate that, but it's definitely stamped the 8th. It was delivered. It was filed here on the 7th and with the other side, but delivered in Bloemfontein on the 8th. And we will ensure that your lordship gets that copy.
Yes. Thank you.
Thank you, my lord. My lord, then, my lord, coming to the issue at hand, My Lord, this is a matter that really should not detain us for long. And I'll just map out what I think are the parameters, my Lord. I've got about 5 different parameters which I will use. Hopefully not use all of them. The first one relates to the matter that is pending before the President of the Supreme Court of Appeal under Section 17(2)(f) of the Superior Courts Act. That is referred to in the papers. Then, and that is the important issue that we want to dwell a little bit on.
No, that's the reconsideration application.
That's the reconsideration.
If we can refer to it as that.
Yes.
Now, it seems to me, Mr. Mpofu, that the factual matrix here is pretty much common cause. I gave a judgment dismissing the special plea. There was an application for leave to appeal with certain adjunct procedures attached to it, which was dismissed in February 16th, if I remember correctly. And thereafter followed a petition, an application to the Supreme Court of Appeal to obtain the required leave where necessary in respect of my main judgment. And that was considered by 2 judges of the Supreme Court of Appeal and was refused, dismissed, I think was the term used, on the 18th, was it?
30th.
Sorry, the 30th.
28th, but it's stamped the 30th.
Yes,
but
yes.
Nothing turns on.
But last week,
yes.
And then following on from that, an application for reconsideration, if I may term it that, in terms of Section 17(2)(f) of the Superior Courts Act, or pursuant to the provisions of the Superior Courts Act 10 of 2013, was then, as you indicated earlier, issued out of the register of the Supreme Court of Appeal on the 8th, after having been issued or served here on the 7th of April 2022. And the issue really becomes one, without wanting to limit your submissions,
Yes.
as to whether this court, I think, has a discretion but to allow the appeal process to run its course.
That's correct.
And then I say the appeal process, i.e. that the President of the Supreme Court of Appeal must consider and reach a decision on this application. The reconsideration application. And that is the case that was made out, or the case initially made out in the application for an adjournment, was based on the petition still being pending.
Itself, yes.
That has now come and gone. It's been overtaken by events. But from the correspondence, which I was copied as well from Mr. Tusini, Mr. Zuma's attorney, and the response of the state from Mr. Downer, it has been broadened to the extent that it now deals with the reconsideration application, which is common cause. It is there, it's in existence, and it's really the consequence that needs to, or that will flow from that.
That's correct. Yes.
And that will entail more specifically a consideration, amongst others, of Section 17 and it seems to me 18 of the Superior Courts Act. The initial application referred to Section 18 fairly obliquely,
yes,
sort of just at the end. It wasn't the main thrust of the initial application for an adjournment, but it's certainly grown in stature, yes, in the heads of argument. And